Sir, one more thing, one question I think, so I'm actually, what are the questions that have come in? What are the situations that our friends are facing? I'm trying to put those into perspective. So one company, they have lots of orders and they have large number of people, and they had to reduce, so because of the fact that they cannot really, pay anymore. So if half of the workforce that he's actually kind of reducing, the way that people have come up is, one of the most important thing is medical insurance, especially the ITES, their salaries are not as per ESIC, they're not covered, but their medical insurance is given. So if they have come to a conclusion saying that, okay, over the next 5 months, maybe 50% of the salary or 30% of the salary, of course, which is more than minimum wage in any case, this thing, but they would like to continue that up to five months, they give a notice period, 5 months, and pay all that 30 or 40% or whatever, but make sure that because the medical insurance is covered. See, what happens is, if they go out, they don't get a medical insurance directly, because this comes in as a group medical insurance. So is that a good practice, sir? From a legal point of view, will there be any issue to you foresee?
Because when it's a group medical insurance policy, it is a comprehensive policy, and you have to look into the terms and conditions of the insurance policy. Whether the moment the employee is out of the employment, whether such employee who is out of the employment after cessation of employment can avail still the benefit of the medical benefit.
So they're not going to stop this thing, sir. They'll actually going to do after 5 months or 6 months. So that means every month they will contribute to the medical insurance, and then it is an agreement between the employer and the employee. So in that case,
the insurance company also doesn't object to it. Okay. That can be extended even after cessation or for termination or retrenchment also. That until this policy period is over, the employer keeps contributing to it and maintain.
Okay, sir. Okay, sir. Now I move on to a bit on the layoff. Now that it's an extension to what we are talking. So, is there an option to retrench or terminate? I mean, can you give some definition of a layoff or retrenchment or a termination? This is very important, because people may use the words as it comes to their mind, because what is their top of the mind. But I think from a legal standpoint, I think we need to know the difference between these, sir.
Yeah, that's good, Mr. R. And I quite often, because I addressed a number of sessions and I've been seeing for the last 33 years being in this line. And as far as ITES is concerned, since 2000, I've been seeing layoff means for the ITES industries, it is only the permanent layoff retrenchment. They mean that.
Okay.
They mean that. When it comes to the manufacturing sector, the layoff means it is temporary laying off the workmen because the employer is not able to give work to the workers. Okay. Maybe for a period of 1 month, 45 days, 15 days. So the perception of the layoff for ITE is different, and the perception of layoff for the manufacturing are different.
Sure.
But forget about their individual perception. Yeah. Let us come to the legality.
Legal, yeah, that's very important.
Yeah. Let us come to the legality. Layoff is only where the employer is not able to provide employment temporarily, then the layoff is used. Where the employer wants to permanently dispense with the services of an employee, then it is retrenchment, it is not layoff.
Okay.
That is the difference between retrenchment and layoff. Okay. And there is also a termination. Yeah. Termination is that, suppose as per the terms of contract, if an employee is employed for a fixed period.
Okay.
So upon expiry of the contract, if he is terminated, that doesn't amount to retrenchment as per the presence of IDI. Then the dismissal means where the employee commits misconduct following the procedure and all, then that is a dismissal.
Sure. Sir, also, I think there's a lot of, see, when the business is shining, when the business is as usual normal, nobody really bothers about some of the non-performers. Okay. Now, suddenly, you see that these non-performers are the, glaringly visible because of the cost that they are adding, and at the same time, no value of, business that they're coming in. So, is there any provisions, if they want to deal with in terms of termination of such non-performers during this time? What are the obligations of employers, and how do they deal with?
Non-performance is also a misconduct.
Okay. Okay.
On any misconduct, if the employer wants to terminate the services, when it comes to the employees who come under the definition of workmen, they got to follow the procedure as has been initiated under the Shops and Establishment Act and ID Act. They cannot straight away terminate them that your performance is not poor, therefore you need not come from tomorrow. When it comes to the non-workman category, supervisor and managerial services, they can be done as per the terms of contract. And ITES industries where there is a non-performance, they put them under the PIP, performance improvement plan, give one or two opportunities. If they don't improve by way of counseling and all, they can directly terminate when it comes to the non-workman category. When it comes to the workman category, they have to follow the procedure laid down under the idea.
Okay. Yeah, I think it's very important. And that's the state of business is they're not really aware of what is going to happen in April. It's going to be really suspense.
Yes. There are other measures, Mr. Jr. Sorry for the interruption.
Yeah.
One thing is that instead of terminating the employees, is saying that you have become excess and I don't have work. Employees can be persuaded with a mutual consent. They can apply for leave, stay at home, and the employer and employee can arrive at an agreement that during the leave period for certain period, 50% of wages can be paid, and for certain period there can't be any wages. Employee also can try his job elsewhere. Rather, totally being out of employment, trying for the job is different.
Yeah.
And while continuing in employment, trying for the job is a bit easy. Another thing is that if he's totally out of the job, he may be in the distress, he may get demoralized, he may not be able to face and get the job. So to win as a win-win situation, it can be worked out. Another thing is that there is another procedure long back in the recession. Some companies, when some 10 years ago the recession came, I did suggest some companies did follow, especially in the ITES industries, where they can say that option is given for the employees to work for 4 hours or 8 hours or 6 hours.
Okay, so reduced time that they can actually do.
No, employee can opt.
Oh, okay.
If he works for 50% of the time of the day, he will get 60% wages.
Okay.
He gives his consent. If he works for 60%, he will get 70% wages.
Okay.
Not full wages. So employee can be given an option so that he would be able to employ more.
That's right.
And the productivity is also more.
Yeah.
This is another method that can be adopted.
I think it's a very good suggestion. I'm sure.
Besides law, we also should have some human touch. Being human is more important than to be the human being.
That's right. I think all the human principles need to be adopted so that nobody is, pushed to corners, because I think that is what is
instead of saying that I have now 60 people, I want only 20, you go out. If they are really, it is on account of non-performance, I quite agree. If they are really talented, owing to the circumstances, throwing completely somebody out, you can say you arrive at a consensus and you can share the work available.
Okay.